So, case happens in 1948. It's based out of Michigan. Um, and in Michigan, there existed a law which denied women the right to obtain a bartender's license unless she was the wife or daughter of a man who owned the bar. So women could not receive a bartending license. First, let's deal with the fact that you had to have a license to be a bartender. Let's just wrestle with that for a moment. But second, that these licenses to be a bartender were denied to women exclusively on the basis of sex, unless they were the wife or daughter of the gentleman who owned the bar. Um, so in this case, a woman from the state of Michigan brought suit claiming that this was a violation of, and this in terms of issue should not shock you, a violation of the 14th Amendment Equal Protection Clause, because they were treating similarly situated people, men versus women, differently under the law. This is 1948. This is after the court has already dealt with racial distinctions in terms of higher education, and it's only a few years, 4 years, before the court deals with Brown v. Board of Education. This is a court that understands 14th Amendment Equal Protection Clause jurisprudence. This is also a court that does not decide in favor of this claim and says that this law is not unconstitutional, and the court says this is absolutely not a violation of the Equal Protection Clause. Justice Frankfurter, writing the opinion, states that the fact that women may now have achieved the virtues that men have long claimed as their prerogative and now indulge in vices that men have long practiced does not preclude the states from drawing a sharp line between the sexes, certainly in such matters as the regulation of the liquor traffic. So Justice Frankfurter quite clearly states that nope, we've allowed women a lot of rights. We've given them a fair amount of stuff, but in this area where men are known to behave particularly badly, states can absolutely put a prohibition upon women entering this environment. So this seems to be very much against all of the 14th Amendment prohibition or all the 14th Amendment jurisprudence that we know. And three judges in dissent make this kind of clear. They actually make the argument very cogently. Justices Rutledge, Douglas, and Murphy argue that while the Equal Protection Clause does not require what is known as abstract symmetry, nor to classify with mathematical nicety, it does require lawmakers to refrain from invidious distinctions of the sort drawn by the statute challenged in this case. So invidious distinctions which cut to the core of stereotypes, or cut to the core of discrimination, like the one in this case, absolutely should be a violation of the 14th Amendment. But a majority of the court in this case says that simply they are not. One thing to point out about this case that might provide it some hope, though Justice Frankfurter's majority opinion, at least through the language it's used, doesn't seem to put it into context. But the 21st Amendment does play, at least legally, a part in this decision. The 21st Amendment provides that the states, and almost exclusively the states, shall be responsible for all regulations in terms of liquor. And thus, the states are given a significant amount of leeway in terms of regulating alcohol. But this decision, at least as we read it, understanding Frankfurter's majority opinion, has to be attributed to traditional gender stereotypes and the doctrine of coverture that still held sway to at least a majority of the court in this case. And that's 1948. I mean, they understand this is after African Americans have begun receiving some victories before the court. Women in something as innocuous as whether a woman could be a bartender was not a violation of the Equal Protection Clause. So let me tell you a story as we wrap up. because I think context is always key to understanding a lot of this. Justice Frankfurter, who writes the majority opinion in this case, was on the court until the early 1960s. In the early 1960s, he interviewed a woman to be his law clerk, a recent graduate from Harvard who had significant credentials and had already clerked for numerous circuit court judges. He didn't hire her because, and this is the reason he publicly gave, because she was a woman with a young child at home and felt that family life would get in the way of her job. To provide sort of an evolution, the woman who didn't get that job is Ruth Bader Ginsburg. Justice Frankfurter turned down Ruth Bader Ginsburg to being his clerk because she was a woman with a family and a young child at home. Man, that is going to go on to just absolutely provide some understanding and definition to the evolution of case law in this area. The evolution of case law, there were a lot of women working on the evolution of law in this context. Starting in the 50s and 60s and 70s, the ACLU was active. No one was as successful as Ruth Bader Ginsburg. And that is the story of a woman who really saw the impediments that were put forward to the legal environment for her. And she breaks them all down. Not as far as she would have liked to have gone, but you'll get a taste of it when we get to the VMI case later on. The taste of what she really wanted.